Thank you. Does anybody have any questions of Ms. Hadley?
Ms. Hadley, thank you for navigating through some very confusing facts and laying that out as succinctly as you did.
Thank
Is there a motion to approve the advocate's recommendation?
Move to approve the advocate's recommendation.
Is there a second?
Second.
All in favor? Aye. I was so frazzled by being late that I forgot to jump to the end of the public session agenda to handle the most important business, which is making sure I don't have to sit here any longer than I should have to, and subject everyone to my voice any longer. So we're gonna jump down to item 9 on the public session agenda. And, well, to the selection of the vice chair. Chair Fuste, I should have started with this, I'm sorry, y'all. Chair Fuste is unable to be here today. We wish him well and hope that he feels better soon. And of course, Commissioner Ankers was formerly our vice chair, and so I'm here today. And so the next order of business will be to select our vice chair, who will complete the remainder of former Commissioner Ankers' term, which will end at the September meeting next year. So if anyone has a nomination and a motion to select a new vice chair, by all means. And they don't have to be present.
Oh, that's when you do it.
Right. Am I allowed to nominate them? Yes. I would nominate Commissioner Deskovich. And she's not here to object.
Good.
I would second.
Okay. Are there any other nominations to vice chair?
I move that the nomination be closed.
Okay. Do I have to have a second for that motion too? Or can we just move on to the vote?
Don't need a
Okay,
second.
that's, all right. So this is where Commissioner Ankers was so helpful in the procedural stuff. So all in favor to approve the motion to nominate or to select Commissioner Deskovich as the next vice chair of the Commission on Ethics, say aye. Aye. All opposed? Excellent. She's going to be thrilled to hear this. So, Ms. Stillman,
You get to continue.
and you get to deliver the good news.
I look forward to that.
I will fumble my way through the rest of this meeting.
It'll serve her right for missing.
That's exactly right. See what happens. No, it's, now let's get back to where we were.
Item 5.
Item 5, which is consideration of a petition for fees and costs in consolidated, this is a petition filed by Ms. Michelle Myers, the respondent in consolidated complaints 23-262, -264, -270, and -278. Ms. Myers' petition seeks to have the complainants, Ms. Diane P. Sykes, Ms. Linda J. Young, Mr. Kevin Tu, and Mr. Christopher Doc Bailey pay attorney's fees and costs following the dismissal of the complaints they filed against her. Are the respondent, complainants, or legal counsel in this matter present?
Yes.
Okay, could everyone please identify themselves for the record?
Your Honor, I'm Susan Erdely, and I'm appearing for Michelle. Do you need me to come up here?
Not for just for purposes of identifying
Okay.
yourself.
I'm appearing for Michelle Myers, the mayor. We're the petitioner.
Thank you.
Your Honor, my name is Kevin Toe, and I'm here for myself. I'm one of the complainants.
Thank you. So I had it right the first time. All right, thanks.
And I'm Doc Bailey. I'm here for myself as well.
Great, thank you for being here. At this stage, if the petition is denied, the case will be dismissed, but if the petition is not denied, the matter will be sent to the Division of Administrative Hearings for a hearing to determine if the respondent is entitled to fees and costs, and if so, in what amount. We have copies of the file in this matter and of the staff's memorandum recommending the petition to be found sufficient, and that the matter should be sent to the Division of Administrative Hearings for a public hearing. The Commission's General Counsel, Steve Zolkowski, will summarize the staff recommendation on the petition. Then we will hear from Ms. Sykes or her attorney, Ms. Young or her attorney, Mr. Toe or his attorney, followed by Mr. Bailey or his attorney. And finally, we'll hear from Ms. Myers or her legal counsel. The parties are asked to limit their remarks to 10 minutes each, and after that, commission members are free to ask questions of either party or of our staff. Are there any members who need to make a disclosure in this matter? Mr. Zolkowski.
Thank you, Madam Chair, and welcome back.
Thank you.
Commissioners, this matter before you is a petition for fees and costs. Between November 14, 2023 and December 5, 2023, the Commission received 4 complaints from 4 different complainants against Michelle Myers, the mayor of Crescent City. The complaints were, in all meaningful respects, nearly identical. The complaints alleged that Michelle Myers, as the mayor of Crescent City, directed the city manager and the city's CRA to solicit a local business owner named Scott King to accept over $44,000 from the CRA for the benefit of his business as a financial gesture to induce Mr. King to run against Ms. Myers' political opponent. To support that allegation that Ms. Myers had a corrupt intent, the complaint also alleged that the CRA's grant program had various application requirements and that none or many of those requirements were not adhered to in the offering of the grant to Mr. King. The complaint alleged that Ms. Myers directed the city manager to issue a recommendation to the city commission to approve the $44,655 grant to Mr. King's business. The executive director found these allegations to be legally sufficient to warrant an investigation as to whether or not Ms. Myers had violated the prohibition against misusing one's position found in section 112.313, subsection 6 of the Florida statutes. There were many other allegations in the complaints, but those were found not to be legally sufficient to warrant an investigation. The commission commenced an investigation into all 4 complaints. At the April 2024 meeting, the complaints were heard for probable cause. The commission advocate recommended that there was no probable cause in those matters, no probable cause of a violation. The commission accepted that recommendation and found no probable cause. With the no probable cause finding, the complaints were dismissed. When a complaint is dismissed, the law allows the respondent to file with the commission a petition for costs and to recover costs and reasonable attorney's fees from the complainant. The complainant is only liable for the respondent's costs and reasonable attorney's fees when, quote, the commission determines that a person has filed a complaint against a public officer or employee or candidate for public office with a malicious intent to injure the reputation of such officer or employee or candidate by filing the complaint with knowledge that the complaint contains one or more false allegations or with reckless disregard for whether the complaint contains false allegations of fact material to a violation of the Code of Ethics. There are legal steps that must occur before the respondent can recover from the complainant. The first step is that the commission must determine whether the respondent's petition for costs and reasonable attorney's fees is legally sufficient. That's the step that we're at now. And I'll discuss more about that in a moment. If the petition is legally sufficient, then we go to the second step. The second step is an evidentiary hearing, the purpose of which is to determine whether the respondent is indeed entitled to recovery. That usually occurs at the Division of Administrative Hearings. The administrative law judge at DOA will produce a recommended order at the conclusion of that proceeding. The third step is a final hearing where you will adopt a final order after having reviewed the recommended order from the administrative law judge. That recommended order from the administrative law judge will contain all of the findings of fact that the ALJ found at the evidentiary hearing. The parties will then be allowed to make and file with you any exceptions, and you will rule on those exceptions as part of your final order in the matter, where you determine whether the respondent is entitled to recovery. The first step that I mentioned is legal sufficiency. We have a rule about reviewing petitions for costs and reasonable attorney's fees for legal sufficiency. It is Rule 34-5.0291 of the Florida Administrative Code. The rule sets out all of the requirements for legal sufficiency to review a complaint for legal sufficiency. Sorry, not a complaint, a petition for legal sufficiency. And I'll go over those now. First of all, you'll notice that a lot of these requirements that I'm about to go over, they have very little to do with determining whether the information in the complaint was actually false or whether the information in the complaint actually was included maliciously. You won't have to decide those ultimate questions until the final hearing, which is that third step that I described. That means that any discussion about whether the Commission's investigator included correct facts in his report is irrelevant today. Disputes about what the evidence is will take place at the evidentiary hearing, which is the second step that I described earlier. The things that you're looking for to determine legal sufficiency today have more to do with determining whether the petition is in order and that it meets certain technical requirements. First, to initiate that process, the complainant must file a petition requesting relief, and the petition must be filed within 30 days of the dismissal of the complaint. Here, Ms. Myers did in fact file a petition, and it was filed 29 days after the dismissal of the complaint. The statute and the rule make clear that a petition may only be filed by a public officer, a public employee, or a candidate for public office. And here, Ms. Myers was a public officer. She's the mayor of Crescent City. The rule requires that the petition shall include the amount of costs and attorney's fees expended by or on behalf of the petitioner through the date of the filing of the petition. On page 12 of the petition, Ms. Myers includes the amount of costs and attorney's fees expended in defending herself during the ethics investigation. Exhibit 15 of the petition, which starts at page 158 of the PDF that was included in your materials, is where Ms. Myers provided an itemized detail of all of those legal expenses. Lastly, and probably where we will spend most of our discussion today, the rule provides that the petition must state with particularity the facts and grounds which would prove entitlement to costs and attorney's fees. To be clear, Ms. Myers does not have to prove those grounds today. You are only looking to see whether the petition states facts and grounds and analyzing whether the facts and grounds supplied in the petition would prove entitlement to costs and attorney's fees, assuming that they are true. This is not a simple prevailing party standard, meaning entitlement to costs and fees is not automatic, just because the complaint was found to have no probable cause of violation. Case law in this area tells us that a petitioner will prove entitlement to costs and attorney's fees when they prove three elements. The complaint must have contained false allegations. The false allegations must have been material to the complaint. And the complaint must have been made either, one, with a malicious intent to injure the reputation of the person complained about, or two, with reckless disregard for whether the complaint contained false allegations. The petition correctly points out that the complaints all alleged that Ms. Myers directed the city manager and the manager of the CRA to solicit Mr. King to accept, on behalf of his business, more than $44,000 from the CRA. The petition correctly states that the complaint alleged that Ms. Myers did this as a financial gesture to induce Mr. King to run for city commission in the November 22 election. The petition states that the complaint supported its allegation with several false facts and indicated that Mr. King did not apply for the CRA funds and that the award by the CRA to Mr. King's business did not comply with requirements from the grant program. But the petition also points out that those alleged requirements were not requirements at all when Mr. King received the grants. The petition cites to the report of investigation, noting that 3 of the complainants indicated to the investigators that they were aware of no evidence that Ms. Myers had actually directed the city manager or the CRA manager to award Mr. King the grant or to contact Mr. King about running for city commission. The 4th complainant, a city commissioner, did not participate in the investigation, and the petition notes that. The petition details the various resources that were available to the complainants that would have shown the complainants that their allegations were false if they had taken the time to research the matter. It is my recommendation that the petition establishes facts and grounds that, if taken as true, would prove entitlement to recovery. The petition states facts sufficient to show that the complaint contained false allegations. The petition states facts that, if taken as true, show the allegations were at a minimum included with reckless disregard for their truth, given that the truth was easily discoverable in public records. The petition establishes facts, if taken as true, to show that the allegations were material to the allegation, or were material to the initiation of the investigation, given that those allegations formed the entire basis of initiating the investigation. To sum up, it is my recommendation that the petition is legally sufficient because it satisfies all of the requirements of the statute and the rule to proceed to an evidentiary hearing. I'm available to answer any questions that you have, of course, and after my presentation, Ms. Erdely will make a presentation and the complainants will make a presentation as well.
Does anyone have questions now or hold them for the end? Thank you. I apologize for getting the order of folks mixed up in the beginning. Thank you for correcting me. Ms. Erdely?
Good morning. My name is Susan Erdely, and over here with me is Michelle Meyer, who woke up at 3 this morning to get in her car in Crescent City, Florida, to drive to appear before you. We filed this petition because the mayor is a citizen of her community, and her good name has been maligned by these maliciously drafted petitions against her. You know, she was here a year ago in front of this board because of yet another complaint filed by Kevin Tu against her. The commission found no probable cause at that time, and on these 4 complaints, again, found no probable cause. The concern we have here, and the reason we filed this petition, is because we do want to deter a chilling effect from maliciously filed complaints against public officials. We understand that public officials are to be held to an ethical standard and that there are rules for that, but the legislature wrote into the statute that if maliciously filed petitions or complaints are made against a public official, that public official should be entitled to recover their expenses, their attorney's fees. As the advocate explained to you, we are not asking for you to decide that today. We're just asking for due process. We want the opportunity to be heard in front of a hearing officer to explain why these allegations are malicious. And if we do not do this, if we did not file this petition, we fully believe that there would be yet more complaints filed against the mayor, and Mr. Tu has filed complaints against many other parties in many other forums. There's the keyboard warrior stuff going on in social media. There have been recall petitions in circuit court. There's been a DCA opinion that is arising out of the mischief of one small group. So this is why she felt it was important, and I feel it's important for you to give her her due process. The filing of a complaint in front of this commission is free. The process is not free. There are professionals who investigate these claims, and we are grateful for the professionals who do that because they have protected Ms. Meyer's good name here. And I shared with you that we're concerned about the chilling effect. We've seen in Putnam County what this small group has done to people who are not running for office because they know that they will be maligned, defamed, mistreated by this small group. They are not above telling lies. They have done that to her. They've done it to others. The very investigator for your commission here has a complaint against him arising out of this from Mr. Tu. So I just want the opportunity to go in front of a hearing officer and explain to the hearing officer not only that these claims against my client were unfounded, that there was no evidence to support it, but that anyone who wanted to find the evidence, there is evidence that the mayor did not do what she's accused of doing in this case. She's accused of directing the city manager and the CRA manager to award a grant to a private business owner. She did nothing more than vote along with the entire board, just like you all vote as a board, and the vote was unanimous. So the evidence is supports your agreeing that we should be heard in front of a hearing officer. We need to stop the mischief. If we don't prove it, then we'll live with that consequence, but we want the opportunity to prove it. You know, the law has changed this year under Chapter 112 to where complainants must have evidence before they file the charge. And this case is an excellent example. It's Exhibit A for why you should find our petition to be sufficient and require a hearing in front of an administrative law judge. Finally, I want to point out to you that Mr. Tu is not a resident of Crescent City. He doesn't live in Crescent City. He has responded to our petition indicating that he resides in Crescent City. That is not true. And I want an opportunity to prove that in front of a hearing officer. So I would ask that you give this woman the opportunity to take her good name back. We don't know that this is going to stop this, but we know that if the complainants with no evidence have some skin in the game, maybe they'll think before they file frivolous claims against innocent people. I'm available if you have any questions.
Thank you, Ms. Erdely. I think so we're going to hold questions to all parties until the end.
Thank you.
Mr. Toe? I thought I heard you say Toe. Is it Toe or is it Toe? It's Toe, okay.
Can everyone hear me? Great. Well, good morning. And thank you all for your time. It's a pleasure to be here today in front of the Florida Commission on Ethics. I'm sure after hearing all that, you must think I'm a terrible monster. You know, I want to just start out and address some of the things that Mrs. Erdely said, specifically about me not being a resident of Crescent City. I've got my driver's license here. I can show you all the information. I've got all my utility bills. So I take that as a personal attack on myself because, again, that information is easily disputed, and I absolutely am a resident of Crescent City. And so I'd like to, again, thank you all for your time. You know, I also woke up today at 3 o'clock in the morning, and I know some of you all have to travel, and so I do thank you for your time. You're doing this on a volunteer basis, and I really appreciate your dedication to serving the citizens of Florida. I want to start by just reading a paragraph directly off of the Florida Commission on Ethics website. The Florida Commission on Ethics is a 9-member commission with a staff of approximately 25 employees located in Tallahassee that serves as the guardian of the standards of conduct for officers and employees of Florida and its political subdivisions, and functions as an independent commission responsible for investigating and issuing public reports on complaints of breach of public trust by public officers and employees. That paragraph, and specifically the last sentence, really hits home to me because unfortunately, throughout this process, I have been treated as a second-class citizen by the same process that's supposed to instill public trust. Ms. Myers, the respondent, had the opportunity to speak with the investigator in person. I was never even notified that the investigator would be coming to Crescent City, so I never had that opportunity at any point. I've tried to reach out to this particular investigator, Mr. Durham, numerous times. I have not once gotten a single response. And I don't believe that this is how the process should work. Ms. Myers' attorney just stood up here and talked about asking the commission for due process. You know, that's what I want as well. I want due process, but I don't feel that throughout the process, citizens in this complaint have been given that due process. So I want to just stand up here, and before I get into the technical aspects of Ms. Myers' petition, I want to just touch upon, there's a specific case that Ms. Early referenced, which is 23-0-83. That was the case last year. That involved a $2,500 check in which the respondent signed to pay for private recall fees. Some of the honorable members may remember that. It's another city commissioner that had not come before the commission, and a vote to, there was no vote to approve that. And so at the hearing for probable cause for 2383, the commission held that it was inappropriate use of city funds to pay for private recall attorney fees, but the Ethics Commission did not go as far as to say it was done with corrupt intent. And so to say that, you know, these allegations have been restated in the instant petition, that is again not true. So turning our attention now to the instant case, the respondent's petition clearly misstates the scope of my allegations and the Florida Commission on Ethics order to investigate. You know, there's a lot of emphasis on some of the statements that I made in the complaint, specifically around directing Ms. Myers directing the city manager, also the CRA manager, you know, but what you don't see in the report is the investigator himself brought it to the attention and said, it doesn't really matter whether or not Ms. Myers directed anybody. The investigator was interested in knowing whether the rules were followed, whether the facts of the matter were that Mr. King did not have to abide by any of the requirements. And, you know, Ms. Myers' petition states that she's entitled to attorney's fees because the complainants failed to conduct reasonable research available online and through public documents before submitting their complaints. Well, I submitted over 150 pages of supporting documentation. None of that documentation showed up on the investigative report. And of course, as I mentioned, my follow-ups to the investigator have not been returned. And so that was why I was left with no option except to file a complaint with the Florida Senate. That was my last option. I did try to exercise the other options to reach out to the investigator, but I have not heard back. And so I've got 4 minutes left. So in terms of the rules, the general counsel stated that before you have to make a decision today on the legal sufficiency of this petition, and you have to follow Rule 34-5.0291, which very clearly states that the elements of a valid cost, a claim for costs and attorney's fees, need to take into account whether the ethics complaint was made with malicious intent to injure the public official's reputation, and whether the person filing the complaint knew that the statements made about the official were false. I'm extremely disappointed at the fact that before you have an investigative report that does not take into account the consideration, the aspects of the information that was provided. My claim in the petition very clearly stated that the rules related to whether or not Mr. King had to apply for the grant, whether or not he had to abide by the fact that he had to get his own bids. None of that information was included in the investigative report in terms of all the supporting documents that I provided as well. In terms of Rule 35-0291, it clearly states the procedure for which the commission needs to act today. One of those being that the information, the petition needs to be forwarded to the complainants by certified mail return receipt. I have never gotten any mail by certified mail related to this complaint, and it actually ended up in the wrong mailbox. And so I don't believe from a technical perspective that that has been met. The other issue that I want to bring up with the commission today is it states that the petition needs to prove entitlement to costs and attorney's fees, and it shall include the amount of such costs expended by. If you go and look at the petition, Exhibit 15 does not have any information on there other than an affidavit of what Mrs. Erdely has billed, but there's no invoice, there's no check, there's no information that's been provided to the commission as to whether or not Ms. Myers has actually even expended any money in this case. And so I think in terms of Rule 34-5, .0291, we have to take into account that the technical aspects have not been met.
Let me ask you, where do you suggest, where do you find authority that she has to attach an invoice to an affidavit attesting to the time that was spent on the matter?
Well, when I look,
I'm asking you what your citation is. Is there a rule that requires the attachment of an invoice?
the rule states that shall include the amount of such costs and attorney's fees expended by.
But does that specifically say that an invoice needs to be included?
No,
Okay,
not.
so that's your standard then, that an invoice needs to be included?
Well, what I'm saying is, as an example, there's
I'm just
no-
asking for an authority and what your citation is for that authority.
Right.
And you're saying that the rule does not require an invoice.
Well,
So-
what I'm saying is that, I may have misspoke. So what I'm saying is that the rule requires it to provide that attorney's fees have been expended by.
Yeah, and she's got a sworn statement and an affidavit that the
Okay.
attorney's fees were expended. So that's, a sworn statement, you understand, is evidence of, in a court of law.
Okay.
Okay. I just wanted to make sure that I wasn't missing something here.
I apologize if I'm interpreting the law incorrectly, but my interpretation was that Ms. Myers had to be the one that had expended the fees.
Well, that begs another question. Is there anything in the rule that requires that she actually pay the attorney for that time and seek reimbursement of those fees?
Well, it says expended by such petitioner.
Right. But is there anything in the rule that says that she has to have paid the attorney for that and be seeking reimbursement?
I mean, I'm assuming expended by.
Okay.
All right. I think in terms of what I would like to close with, again, I'm very disappointed in how the process has unfolded. I think if citizens are expected to file honest complaints, they should not be in a position where when they look at the investigative report, there's absolutely not any mention of the evidence that was provided, and there's no clear indication that the same process was upheld. I'd like to just, is it okay if I make just a couple more
30 seconds.
statements? Okay, all right, thank you. Actually, I'm good. Thank you so much for your time.
Thank you.
Thank you.
We'll hear from Mr. Bailey next. While Mr. Bailey is getting prepared to make his remarks, could I impose upon you, Mr. Zolkowski, for a favor? I understand, everyone's very emotionally invested, and I appreciate everyone's thoughtfulness and conscientiousness. Mr. Zolkowski, could you just remind everyone as we're hearing from the last person, the discrete question that we as a commission are being asked to answer today, and what we are by law allowed to consider in making that determination?
Sure. So you're considering today the legal sufficiency of the petition. It is the petition that is at issue today, whether or not the petition is sufficient to allow this matter to proceed to the next stage an evidentiary hearing, which would be held at the Division of Administrative Hearings. So you're looking for whether or not the petition lays out the facts and grounds that would be entitle Ms. Myers to recovery. You're looking for whether the petition states, I'll give you the entire list here. You're looking for whether or not the petition was indeed filed within 30 days, whether or not there was a petition in the first place. You're looking for whether whether Ms. Myers is a public officer. You're looking for whether the petition details the amount and costs of the costs and fees expended by or on behalf of the petitioner through the date of the filing of the petition. And then, as I mentioned earlier, you're looking for whether or not there are facts and grounds stated in the petition that would prove entitlement to costs and fees.
So we are limited to the four corners of the petition in our review today. Is that correct?
This is not an evidentiary.
So we're not to concern ourselves with the investigation or the investigators' actions?
Right, as I said in my presentation, we're not concerned with.
So I don't think they can hear you on the live feed, so if you could speak. Mr. Bailey, would you mind if Mr. Zolkowski uses the microphone at the podium for a moment to finish answering this question?
Sure.
Thank you.
Excuse me, sir, I'm sorry.
I want to make sure people on the live feed can hear.
No.
You can stay up here, Mr. Bailey, if you'd like. I apologize for throwing everything out of order.
The question was whether or not we are concerned with the
Investigation.
performance of the investigation, and the investigation is reviewed at the probable cause hearing, and whether or not there's enough in the terms of the investigation are reviewed at that point. So we're not reviewing whether or not we followed our investigatory procedures or the quality of the ROI at this stage. If there is a dispute about certain facts that might tend to prove or disprove entitlement to recovery, well, disputed facts would be resolved at the evidentiary hearing, so that would be an argument for proceeding, if anything.
All right, thank you. We'll,
Thank you.
I'll hold fire until the end. Thank you, Mr. Bailey. You can go ahead,
You ready?
please.
Hey, good morning, everybody. My name's Doc Bailey. I got the Doc handle from my real name, Christopher. My mom's the only one that calls me Christopher, by the way, only when she's mad. But I was a live flight medevac pilot, chief warrant officer in the military for 12 years.
Thank you for your service.
You're more than welcome. I tell everybody they taught me how to fly, give me a government credit card and a $16 million plane. I'd have done it for free, but I wasn't going to tell them that. But I've committed my life, entire life, adult life, to service, saving someone's life every day. I flew 10 years after that as a civilian EMS pilot. I have over 6,000 flights of saving people's lives. People matter to me every day. I used to count the number of lives that I'd save at the end of the month. Bottom line is I moved this community after I served my service, and hailing from Kansas City, I have a barbecue place that's out of this world. So I do real craft Kansas City barbecue. All that being said is I'm a very active member in this community. I will tell you right now and look you dead in the eye, I made no malice toward these petitions or documents that I had done. I was present when the mayor said that yes, or the city manager said yes, that we didn't ask anybody else in the community, didn't open it up to the other businesses, that we're going to give this guy this money, $44,000, the entire amount of the year's budget for one person. Now, I'm a business owner in this community. Why wasn't I asked? Okay, nobody was asked. And when asked what happens, and then the next month, he's in their corner going up for election against the one person on the commission that she doesn't like. The only person that doesn't vote unanimously with the mayor, she doesn't like. So you tell me. I wrote that. I saw that. It's my civic duty to go, why wasn't this taken care of? Why is one person getting $44,000, the entire budget? To me, that's an ethics question. I meant no malice. If she has a problem with her reputation, it's because she caused it. I am just reporting what I saw and what is there. On the check, the first one that was here last year, I was involved in that also. I was the commissioner who handed her the check that she signed that didn't come before the board, that was $2,500 directly to another commissioner for her legal fees for recall, of which they got rid of the police department, which she said she wouldn't do when she was elected. To me, I went, wait a minute, you're using government money to pay off a private attorney fee with a check that you wrote, not coming for the commission. Anything over $1,000 has to become the commission. That was me then. I handed her the check, and she admitted in open forum that, yeah, that should have run for the commission. Who wrote that? Her name was on the bottom of the check. This didn't come before you any farther. There was no probable cause or whatever. I don't understand that, but I can tell you, I didn't do it with malice. I'm protecting the people's money. Now, if that's wrong, I'm in the wrong spot. That's my job. It's my civic duty to do that. It's my civic duty to find out where $44,000 is going to one person for. There is no malice in this. This is exactly what happened. Why it doesn't come forward to you and you guys go, why did you give this guy the money? I don't know. But I can tell you, I'm a little upset and a little discouraged of the two things I do in my entire life that I think is wrong, and I'm serving my community. Please tell me where I'm at malice and ruining her good name. She signed the check, not me. All I'm doing is trying to find out why she signed it, why it didn't come before the commission. Why would you write another commissioner a check behind closed doors? And the only reason why it came up is because they were 8 months behind in doing the audit of the year, and I was looking through the books trying to figure out what's going on. Oh, what's this? A check that never came through the commission. Now, you tell me if that is an ethical violation. I think it is. It didn't go any farther than what we are now. But all of a sudden now, the whistleblower is going to be asked to pay her attorney's fees when, you know, I'm not the one who gave him the money. I didn't write the checks. All I did is find it. All I did was ask them, why didn't they open it up to the other businesses of the community? 4 of us got together and said, someone has to do something. Squeaky wheel gets the grease. What would you do? We read an honest, blow-by-blow description of what we saw. Not that, oh, this evil woman did this. That's not my job. My job is to protect the people in the community and their money, of which the city's broke. We're the highest paid tax city in the county. We have the highest taxes of all of it. Spending $40,000 on Christmas trees. I ran because I wanted to stop that. Now, bottom line is, I can't do everything, but I can tell you one thing. I know the people that I was with when we decided to go over this stuff had any malice whatsoever. We had to draw attention because this being unchecked, how many other checks are there out there? How many other people are getting money that nobody knows about? We're just a watchdog. And I did very little. I only did 2 things that happened in front of me on 20 that I could tell you that make your skin crawl. How'd you like to have somebody come up as a commission member and say, I want to be on the tree board? And then have the mayor and the commissioner go, oh no, you signed a recall petition. You can't be on. You're blackballed. That, to me, was an ethics violation. Never got reported. can't report everything. You just have to pick and choose what you think would stick. Those two, $44,000 and a $2,500 check that didn't go before the commission, that was written outside the guidelines of the city charter, I thought was a slam dunk. I'm sorry, but I'm naive. I don't know this process. I don't know what goes forward and what doesn't. The only thing I can tell you earnestly and without false statements is that's what I saw. That's what I filed. And that's all I can tell you. And yes, ma'am, I got up here at 3 o'clock in the morning and drove all the way here too. We all do. This is important to us all. It's my good name too. You know, the last thing I need to be thought of is 2 reports in my entire life. Neither one of them did any good. I won't write another one. You could shoot somebody in the street, but I'm sorry, I won't write another one. And that is a shame. And if you think charging somebody $11,000 for that, how many people you think are going to come up here? You guys will be out of business. Ain't nobody going to come up and do a violation if they think they're going to get stuck with it. That's why they have whistleblower laws. I thank you for your time. And I appreciate everything that you do. Believe it or not, I do. But I just wish that you guys had the whole story and not parts and pieces. And frankly, on this one here, I was never even contacted to do a statement. Didn't know that he was in the city. Didn't know this existed. The reason why we're here today, I got notice of this 2 days before the last one was continued. I didn't even know about this. Nothing. Miss Millie says, hey, you going to be there for the... What are you talking about? I had no idea that I was even in part of this whatsoever. Nothing. I didn't even make a statement to the investigate the deal. Didn't even know what was going on. I just thought, oh, well, I submitted it, round paper file. Forget it. I don't even know what's going on. Absolutely no response, correspondence whatsoever. I just figured it was dropped. So to say that I filed something in malice, absolutely false. I made any false statements? Absolutely not. And I thank you for your time.
Thank you, Mr. Bailey. I'll open it up to questions for anyone who's presented, as well as any items for discussion.
So, Mr. Zulkowski, just to confirm again, we're not to concern ourselves with the complaint that was previously brought by the complainants or the investigation. We're only to concern ourselves with the petition for attorney's fees today. Is that correct?
That's correct.
So we have a very limited scope of review today, correct?
Through the chair, that is correct.
Okay, so we're just to concern ourselves with the petition for fees as to whether or not there's been a prima facie allegation or bare bones allegation that meets with the requirements for a claim for attorney's fees, correct?
That is correct. The question before you is whether the petition states the grounds.
Okay.
As far as proving those actual grounds, that doesn't happen here today.
That happens before the Division of Administrative Hearings at a subsequent hearing.
Through the chair, that is correct.
Okay.
And I have a comment too. So those that came and wanted to voice their opinion about their investigative report, they could go to the next meeting and state the same things that they stated today, right?
That is correct. In fact, it's my understanding that that these concerns have been voiced to the investigative manager of the Commission on Ethics. You know, our investigator's supervisor. One of the complainants did email him. Mr. Toe did email our investigative manager and had a back and forth with our investigative manager about his thoughts about the investigation. And so, all avenues were not foreclosed here, but that having a discussion even about that today is not appropriate. But so to answer your question, yes, we have we make ourselves available for that.
Any other questions, comments? All right, is there a motion on the staff recommendation?
Move to approve the staff recommendation?
Is there a second?
I second.
All in favor?
Aye.
All opposed? All right, the motion passes. Thank you all for being here today. And then who's going to be in touch? Megan, okay, okay. All right, we'll move on to item 6 of the agenda, which is consideration of advisory opinions. This is file 2815. Any public officer, candidate for public office, or public employee in Florida who's in doubt about the applicability of disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Is the requester in file 2815, Lauren Levy, in attendance? Oh, thank you for being here today. Ms. Naomi, you can proceed.
Thank you. So this is an opinion requested by Mr. Lauren Levy on behalf of his client, who's a property appraiser. This opinion concerns some issues that the commission has previously opined on, and the guidance provided regarding those issues is consistent with past commission precedent. However, the commission has not previously had the opportunity to opine on how a reporting individual should disclose monetary donations received via a charitable auction set up on his or her behalf. To provide some context on this situation, the property appraiser, his wife, and his 2 teenage daughters recently traveled from Florida to Texas to participate in a junior livestock show. As the family traveled home after the show, they were involved in a tragic motor vehicle accident. The accident resulted in significant injuries to the property appraiser and his family. Additionally, his truck and his livestock trailer were totaled, and the livestock had to be euthanized. Participants in the livestock show circuit are a close-knit community, and news of the accident traveled quickly. Within a few days of the accident, the property appraiser became aware that an acquaintance of his had set up an auction site whereby individuals could donate items for bidding and/or bid on those items. The proceeds of that auction were intended to help offset the costs and expenses that the property appraiser incurred as a result of the accident. The auction website was live for approximately 1 week, and ultimately, $101,590 were raised. Fortunately, the property appraiser has spreadsheets that include the items donated, the name and contact information of those who donated the items for auction, the name and contact information of those who bought the items, and the auction price, or the winning bid, of each item. According to the property appraiser, none of the individuals on the list appeared to be lobbyists or vendors of his office. The auction also included 6 anonymous winning bids. However, none of those bids exceeded $100. So against this backdrop, Mr. Levy has asked how his client should disclose his acceptance of the funds that were raised in the auction. The property appraiser may accept the monetary donations raised from each winning bid, as long as neither the donor of a particular item nor the winning bidder of an item is a lobbyist, vendor, principal of a lobbyist of his agency, or a political committee. Again, I would like to point out that from the property appraiser's review of the list of donors, none of them appear to be any of these prohibited sources. Regarding the anonymous donations, based on the information provided, none of those exceeded $100. Thus, the property appraiser may accept these donations as well. This is distinguishable from what this board opined on in opinion 24-5, in which you may remember that this board said that the reporting individual there could not accept anonymous donations over $100 due to the risk that one of the anonymous donors could be a prohibited source And under Section 112.3148 sub 4, reporting individuals may not accept gifts valued over $100 from vendors, lobbyists, principals of lobbyists of their agencies, or political committees. So where the donations are not being offered to influence the property appraiser's official decision-making and are not being offered by any of these prohibited sources, we can just narrow our focus to Section 112.3148 sub 8 Florida statutes. Essentially, this provision requires a reporting individual or a procurement employee to disclose all gifts valued in excess of $100 unless they are otherwise prohibited by other parts of the statute. The gift disclosure must occur by filing a Form 9 quarterly gift disclosure by the last day of the calendar quarter following the quarter when the gift was accepted. The proceeds from each individual auctioned item that are greater than $100 must be disclosed as separate gifts on the property appraiser's Form 9. This is also consistent with the reasoning in Opinion 24-5, as each gift, in this case, each individual winning bid for an auctioned item, occurs independently of one another. Rule 34-13.400 sub 3 in the Florida Administrative Code governs Form 9 gift disclosures. This rule states that the Form 9 shall include a description of the gift, the monetary value of the gift, the name and address of the person making the gift, and the dates thereof. Thus, to make a proper disclosure on his Form 9, the property appraiser must disclose, among other things, the value of each gift that he receives. As a general principle, gifts are valued using the actual cost to the donor, unless the gift law provides for a more specific valuation method. As I mentioned earlier, this board has not previously had the opportunity to opine on how to value monetary donations that were the proceeds of a charitable auction for the benefit of the reporting individual. Therefore, in this instance, we suggest that this board finds that the value of each gift for purposes of disclosure is the winning bid amount for the auctioned item, as that is the amount of money that is ultimately being given to the property appraiser. Taking into account the rest of the requirements of Rule 34-13.400 sub 3, when filling out his Form 9, the property appraiser must disclose a description of each gift. In this case, it would be cash. He must also disclose the monetary value of each winning bid, which is the value of the gift, and the name and address of the person making the gift, as well as the date the gift was accepted. So although we're suggesting you find that the value of each gift is the winning bid amount for the item that was auctioned off, we suggest that this board finds that both the winning bidder and the person who put the item up for auction should be disclosed as the donors of the gift. The rationale behind this is that it takes both the participation of the donor of the auctioned item as well as the winning bidder for the gift to occur. But for both parties participating in the auction of a particular item, the property appraiser would not have received a monetary gift. Now, although the winning bidder is the person who's actually providing the funds that the property appraiser will receive, the donor of the auctioned item is creating the value in the transaction. This is also in compliance with Rule 34-13.400 sub 7, which states that when a gift valued over 100 has been given to a reporting individual or procurement employee by multiple donors, the names and addresses of all persons or entities who contributed to the acquisition of the gift shall be reported, unless unknown. This analysis would be different were a vendor, lobbyist, principal of a lobbyist, or a political committee to have been a contributor, as no prohibited source may contribute over $100 to a reporting individual, even if the gift is from multiple donors. So the date that the property appraiser should use for purposes of disclosure on his Form 9 is the date that he accepts the funds from the auction account, not the date that the items were auctioned off. This is distinguishable from instances where a reporting individual sets up his or her own crowdfunding venture, as he or she would have access to the funds immediately after they are donated. In the case of this property appraiser, however, the funds were not immediately accessible to him, and the auction was not set up at his request or with his knowledge and consent. As previously alluded to, the property appraiser has two spreadsheets, one containing information about the donors of each item to be auctioned off, and one containing information about the winning bidders for each item. Because the property appraiser ultimately received 196 donations for 196 auctioned items, these spreadsheets are quite voluminous. Thus, the property appraiser may comply with the disclosure requirements by attaching these spreadsheets to his Form 9, as they contain the information that is required for proper disclosure under the Florida Administrative Code. Now, as I mentioned earlier, this opinion also addresses other issues that have arisen from this situation. However, the advice provided concerning those issues is consistent with past commission advisory opinions. So before I finish, I also wanted to add that yesterday we received communication from Mr. Levy that the property appraiser accepted the auction funds on October 15th, which is after the initial request for an opinion was sent in. Although this does not change the outcome of this opinion or the advice that we're rendering, I would suggest, should you choose to make a motion to adopt the draft opinion, that you also allow me to make small changes to reflect that the property appraiser has already accepted the gifts, as the draft currently states that Mr. Levy's client has not yet accepted the funds. So with that, I'm happy to answer any questions any of you may have about this draft opinion.
Thank you. The one question I have is, well, first, just so I'm clear, what the opinion says is that in this situation, for the charitable auction contest, you need to disclose the donor, the winning bidder, and the amount of the winning bid. Is that right?
Yes, that's correct.
Okay, if someone, the recipient makes a reasonable inquiry and finds that the donors of some or all of the gifts, thinking about future contexts, all of the donors are anonymous, or some of the donors are anonymous. That's something that happens with charity auctions sometimes. Would the person making the disclosure have to just disclose the winning bidder and the winning bid in that situation?
After a reasonable inquiry, I think that would be the way to go. However, the rule states that if any of the information that's required on the Form 9 is unknown, the Form 9 shall so state. So I would suggest probably, if that did happen in the future, the person would have to make a notation. But again, in 24-5, this board has said that, people cannot accept anonymous donations over $100, so that might not even become an issue.
Okay. That was the GoFundMe opinion. Does anybody else have any questions? Is there sorry. Thank you, Ms. Naomi.
Yes.
Ma'am, would you like to be heard on behalf of the requester? Okay, thank you for being here. If there are no other questions or discussion, is there a motion to adopt the draft opinion?
So move.
Is there a second?
Second.
All in favor? Aye. All opposed? All right, the draft opinion is adopted.
Through the chair, I just wanted to clarify, does that motion include language so we can amend it to reflect the facts accurately that he has already accepted the?
I'm so sorry. Yes. Do we need, sorry, I'm getting ahead of myself. Do we need to make a second motion?
Commissioner Bush, did your motion include the ability for her to
Yes.
make those notations in the draft?
Yes.
In the opinion?
Thank you for that. Okay. I appreciate that, y'all. Okay, moving on to item 7, consideration of rulemaking. We've got 3 rule hearings on our agenda today. And the purpose of this public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. Following public hearing, the commission will decide whether to make any changes in response to public comments or written materials received, or whether to accept the rule as noticed. The commission may withdraw a rule in whole or in part, or make changes as are supported by the record of this public hearing or any written materials we've received. The commission also may make technical changes that don't affect the substance of the rule. I'll ask Grace Shaper to explain the rule changes for Chapter 34 34-5 to start and put us in the proper posture, and then we'll proceed with the public hearing, deliberation, and vote. Mr. Schaefer?
Thank you, Chair. Commissioners, this particular series of rule amendments all pertain to rules in Chapter 34-5 of the Administrative Code. That's the rule chapter that sets out the protocols and the procedures for how the Commission should review and handle ethics complaints. The rule chapter itself is made up of about 25 individual rules, each with different subsections. You actually have already engaged this year in some rulemaking regarding this particular rule chapter. Now, during this past legislative session, the legislature passed Senate Bill 7014, and the governor signed that into law in June. The new law had several different sections, some of which, like I said, you've already engaged in rulemaking on, but one particular section didn't go into effect until October 1st of this year. That particular section sets out new timeframes or deadlines for each stage of the Ethics Commission complaint process, like how much time the Commission has to review an ethics complaint to determine if it's sufficient for investigation, how long the investigation should take, then how quickly things should proceed once probable cause is found. All of these changes were made in Senate Bill 7014 to Section 112.324, which is the ethics complaint law. There's no wiggle room on these changes. The law is very clear about the new time limits. So now we just need to go back through our rules chapter on complaints and update the rules to reflect these new timeframes given in the statutory amendment. The changes are pretty extensive, so unless there's any questions, I'm not planning to go through each of them one by one, but I will say each individual change has been noted in the memo in your meeting materials for this agenda item, and that memo gives you the updated citation to the statute that warrants the change. We're not engaging in any independent thought here. All we're doing is we're going back through our rule chapter and we're plugging in these new timeframes. Now, all of these changes have been noticed in the Administrative Register. All of their language has been provided to JAPC, which is the state agency that reviews rule changes to make sure the agency has authority to make them. As of yesterday, JAPC had no feedback for us, which I think is a good sign that they're comfortable with these changes. So I submit these changes that just concern timeframes to you now. I'm happy to answer any questions you have.
Are we able to ask you any questions now, or do we need to move on to first let anybody from the public? Is anybody here from the public on this rule? No. No? Okay. All right, does anybody have any questions of Mr. Schaefer? Okay, is there a motion to file the proposed rule amending Chapter 34-5?
Moved.
Second?
Second.
All in favor?
Aye.
All right, so that brings us then
I don't think you have
to,
any choice.
all right, 34-17. And, well, I can ask as we go. All right, Mr. Schaefer, if you want to proceed then on 34-17.
Sure. Commissioners, this particular series of rule amendments are all very similar to the rule hearing we just held. That hearing is about updating our complaint rules to account for these new deadlines, but the deadlines also apply to referrals as well. So this particular rule hearing pertains to Chapter 34-17 of the Administrative Code. That's a rule chapter about referrals. We're just going through the referral rules and making the same changes we just made to the complaint rules. Like before, all these amendments have been properly noticed in the register. JAPC's had no feedback for us on them, so I submit them now for your review.
Thank you. Is there anybody from the public on this rule? No. Are there any questions or comments from the members? Motion to file the rule as proposed, or the proposed rule for adoption? Motion?
Moved.
Second? All in favor?
Aye.
Thank you, Mr. Schaefer.
Thank you.
Okay, and Ms. Naomi, could you explain the changes and put us in the proper posture for the amendments to Chapter 34-6?
Yes. So this rulemaking is intended to update certain aspects of 34-6 regarding the Commission's advisory opinion process. So the particular amendments in question, which I'll be discussing, concern subject matter that the Commission may render advisory opinions about. The first two amendments are just intended to catch the rules up to current state statutes. So first, the rule will be amended to indicate that the commission can render advisory opinions regarding the standards of conduct, meetings, and membership of the Florida Gaming Control Commission, as is now prescribed by statute. The rule will also be amended to indicate that the commission can render advisory opinions regarding former commissioners and employees of the Florida Public Service Commission, as well as the issue of representation of clients before that commission. This is also prescribed by statute. Finally, the rule will be amended to change a reference to a separate rule that has previously been repealed, so that reference will be removed. If you have any questions regarding any of these amendments, I'll be happy to answer them. So far, we have gotten no feedback from JAPSI on these changes, which I take as a good sign.
Thank you. Is there anybody from the public on this one? My only question on this one was, for both the Gaming Commission and the PSC, those statutes explicitly direct us to issue opinions for these.
Yes, and
Okay.
the specific cites to the statutes are in the materials.
Okay, and I think I looked at all of them, but I want to make sure. So this is another example, we're not really engaging in any independent thought. on
Yes,
this one.
yes.
Okay. Does anybody else have any questions or comments? Is there a motion to file the proposed rule?
Move to file?
Is there a second?
Second.
All in favor?
Aye.
Aye.
Thank y'all. All right, moving on to item 8, consideration of our proposed fiscal year 2025-2026 budget. Ms. Stillman's prepared the draft proposed budget, which was provided in our supplemental mail-out and is included in the materials we have today. And I'll recognize Carrie to walk through her plans for the commission's upcoming budget request for the commission and the commission's executive branch lobbyist registration trust fund, which will be subject to change depending on instructions from the legislature. After questions and discussion, the commission will vote to approve the proposed budget in concept with the understanding that some of the information in the proposed budget could change based upon more updated information provided in the parameters that are set by the House and the Senate. Ms. Stillman?
Thank you, Chair. Members have been working the last number of weeks on the commission's budget, and I work with the Office of Legislative Services and their fiscal office and accounting office in putting this material together for you. In your packet, both for the executive branch lobbyist trust fund as well as the commission's budget, you'll see that you have a fact sheet, which is a 3-year look at the budget. You will also see an operating budget as well as a copy of the listing of the contracts that the Ethics Commission currently have. So I'll briefly set this up for you. Of course, we're administratively housed in the legislature, and staff are legislative employees subject to joint policies with regard to personnel. We received instructions from the legislature related to our budget request for the fiscal year. And the House and Senate will contact me with any questions that they have about our budget. As a legislative agency, we receive sort of a line item appropriation within the General Appropriations Act, and the operating budget sets forth the expenditures, proposed expenditures we plan to make in the area of salaries, OPS, and expenses. So for the Executive Branch Lobbyist Trust Fund, we have one employee who works downtown in the Pepper Building. The Executive Branch Lobbying Office is co-located with the Legislative Lobbying Office, and we split those expenses with the legislature in terms of the housing of the office and the costs related to that. We currently pay 48% of those office costs. Again, the funding is not taxpayer dollars, rather it comes from the lobby registration fees of $25 per principal, and late compensation reports filed by lobbying firms accrue a $50 a day fine for each day late. All lobbyist registration and compensation reporting is done electronically with an electronic system that we put together a number of years ago. Regarding the proposed operating budget, the salary budget includes funding for our employee who functions as our registrar Karen is fabulous. She does a great job on behalf of the commission. The budget remains generally consistent. We come in under budget. The margin is thin. Also included in the salaries budget is salary support to the commission in the amount of $25,000, which accounts for time the attorneys, Steve and I, spend in relation to executive branch lobby registration office duties that we carry out throughout the year. The OPS amount that you see under other personal services contractual, you'll see that there is a $75,000 proposed expenditure in that particular accounting and auditing services under OPS. That goes to pay for the audits. Each year, we're required by statute to do random audits of a certain percentage of the registered lobbying firms. And we do that in conjunction with the Legislative Lobbying Office. It's a random drawing that's done usually each February. Because it is random and it is a drawing, we never know who is going to be selected for that lobbying firm audit. Therefore, we don't know how large the lobbying firms are going to be or how expensive the audit is going to be. $75,000 was the amount that I put in based on about the last 10 years of audits that have been done. I felt confident that that would be an amount that should cover it. The caveat there is this year's audits have cost us $200,000. So when we overshoot, and there's no way to know because we put in the budget request, then they select the firms that will be audited, and then the audits are undertaken. So by the time we're doing the audits, the budget is already in place, and we have to wait to see what those costs are. That's where carry forward dollars come in, and I make a request that the legislature permit us to use carry forward dollars to cover those expenses, and that has been what has happened in the past when there has not been sufficient funds in the OPS operating budget to cover that amount. That's really the biggie. The other largest item on here is the rent for the building, and DMS appropriates, gives us administered funds if the rent goes up. So that covers it for executive branch. If you have any questions, I'm happy to answer those. If not, I'll move on to ethics. Okay. So turning to the commission's budget, again, you'll see the fact sheet categorized into salary, OPS, and expenses. You will also see listed there risk management for $43,799, as well as an item for administrative hearings. The anticipated amount for administrative hearings in the upcoming fiscal year is $24,807. And so those are static costs, they're direct transfers. When we look at the commission's salary budget, obviously that is the largest part of our budget. Most of the increase to the salary budget for the upcoming fiscal year is due to increase in benefit costs. There will be increase across the board in benefit costs, but also we end up with benefit cost changes and increases when folks have different qualifying status changes. Also, accounting for the increase in the salaries budget is our personnel plan for the upcoming year, which I've included funds for a position vacancy, possible merit increases, as well as position reclassifications. We're seeking some reclassifications in order to help manage the commission's adjustment and responsibilities due to the enactment of recent legislation that has, as you know, changed the timelines that the commission operates under. We're under some tight timelines there, and we're currently adjusting into that phase. So at this point, we think that certain reclassifications will help us manage that without having to move to seeking additional positions with the commission. Again, the executive branch reimbursement is shown on that operating budget for the commission under the salaries as well. And that $25,000 is a reduction from previous years. This year was the first year I reduced it, and that's because with it being electronic and having Karen downtown, things run very, very smoothly, so we're not having to spend as much time in the day-to-day of executive branch as we have before. So barring anything unforeseen, I believe that based on anticipated staff changes and adjustments, the fiscal year salary budget can be accomplished with a salaries budget of $2,263,696. Moving to the personal services contractual relationships category, everything in our budget generally remains the same. They refer to that as a continuation budget, but we do have some things of note that I like to talk to you about. One significant item is our contract with the Attorney General's office. You'll see we have a contract in place, as you're aware, to handle outside litigation costs, and I have $50,000 allotted for possible litigation costs related to lawsuits that are currently pending or any others that could be filed in the future. But significantly, our biggest item in there is our contract with the Attorney General's office for the provision of commission advocates. Currently, the commission has 2 advocates and 1 administrative support person in the office of the Attorney General. Their initial budget request for that was $473,540. Since that time, and given the new responsibilities under the law that was passed during the legislative session that shrunk the time for the commission advocate to provide their recommendations to the commission to no more than 15 days, the Office of Attorney General let me know that they will be seeking 2 additional positions to add to their staff to make sure that they're meeting the policy goals of that legislation. So they're asking for 2 new positions, a new attorney and a new support staff person. And they've also asked for us to include in our budget request for funds to cover across the board 5% increases should the legislature elect to include that as a part of the general appropriation and should the governor sign that into law. If those across the board changes cost of living increases are put into the budget, the commission would not receive those administered funds because the advocates and their support staff are employees of the Office of the Attorney General. So we would have to be able to cover those costs that we're invoiced for. So that has increased the amount, and you'll see in there the amount that I'm seeking is $671,152,000 for the Attorney General's contract. Turning to expenses, you'll note, despite having electronic filing, we do have a lot of postage in our office. That stems from both mainly the belt and suspenders approach we've taken to rolling out electronic filing. We want to make sure in these first few years that word is getting out to folks. If they're not checking email, that they're reminded to check their email because their habit is to check the mail. But also postage costs have increased, as well as shipping costs. In addition to that, the data circuits, that's our connectivity fee for Suncom, for our computers, et cetera. We have a travel budget of $52,000 that I'm proposing. That is for the costs of not only your travel to and from commission meetings, but for our investigators to be able to travel throughout the state and conduct investigations related to complaints. Aside from that, our property rental comes in at $101,917. That is for the current lease that we entered into and that this commission approved within the last few years. We also have a contract with Westlaw, of course, and you see that in the online electronic subscriptions category for our legal team to be able to do legal research. And that's one of our biggest contracts outside of the Office of the Attorney General and the lease. And so that takes us through expenses. I believe the total expenses anticipated are $294,417. A couple of other items I wanted to bring to your attention. We had the call center in 2024. We'll be doing that again in 2025. On your fact sheet, you'll see an amount allotted for under contractual services. I've estimated there $400,000. That's actually an amount that includes what I think could happen in terms of a call center, and we'll be doing an RFP for that, as well as a significant expense replacing our Alchemy software management system. Alchemy is what you love. It is the program that we use for the meeting materials, but that program is at end of life. We have been notified by our information technology folks that we need to pick something else. We have been working with them closely to identify something that will work for our office and be cost-effective, because there are a lot of things out there. A lot of them are very expensive. Alchemy has only cost us maybe $7,000 a year in licenses, but now we have to get a little bit more with the modern age. And so I anticipate that we'll be able to implement something for about $113,000. That is an estimation. We won't know till we go through the purchasing process with our IT folks. We have identified a program with OLITS that we think will help, and that cost would include the most significant part of that cost, which is the migration of the current data. Alchemy not only handles your meeting materials, but it's our day-to-day workforce in the office. Everything that gets scanned related to complaints, everything related to opinions, litigation, financial disclosure, all of our paper financial disclosure forms for the past 10 years are all housed in Alchemy. All of that will have to be migrated over, and that is no small feat. So as we work towards getting that quote, my expenditure authority is $10,000. You will be seeing the information on that software program come before you for your consideration and approval in the coming months once we have something from OLITS on that. So those are the big items in the agenda. If you have any questions, I am happy to answer those questions for you.
Thank you.
If not, if there are no questions, I would ask your support of this budget, at least in concept, recognizing that I might have to make a few tweaks based on feedback from downtown.
So moved. Second.
All in favor?
Yes, I've got it. Thank you. I appreciate your support. As you know, we always strive to be good stewards of taxpayer dollars, and we do come in under budget each year.
And, did you have a separate, Ms. Stillman, did you have a separate executive director's report aside from the?
Madam Chair, you know I do.
Well, let's hear it.
Commissioners, you have your written executive director's report, but I have a number of introductions to make today, and I'm really pleased to be making them. Joining us in the gallery today for her first day of work is a new member to our legal team, Stephanie Novinario. You'll see her raising her hand. She joined our staff today. She has a variety of governmental legal experience. She comes to us from ACA. And with that hire, we have finally rounded out our legal team and will be operating with a full legal staff for the first time in too long. And so we are very, very excited to have her with us. Also joining us in the gallery, I mentioned him, I think, at the last meeting, but Michael Wiederspan is our newest investigator. I say new, but he came out of retirement from the Federal Bureau of Investigation to join our staff and has been working hard for us, and we're really happy to have him with us, and our investigative team is also fully staffed now. In addition to that, Ms. Hadley, our commission advocate, has finally been able to hire an attorney to join her as advocate. She has been a one-woman show for several months, and including with the new requirements of the law. And I don't believe you have an assistant right now either, do you? No. So literal one-woman band over there. But joining her is Joseph Burns. Mr. Burns, Commissioner Figures, Commissioner Lucas, you'll recognize Joe. He used to be a member of our staff. So we are confident that Melody's got a good one there, and that's why when we say goodbye to people when they leave our office, we say it likely won't be for long. We'll see you later. And so we're glad to have him back aboard with us, and we look forward to working with you, Joe, once again. So that is all of my staff announcements that I have. What's next? Legislative report?
Well, first, welcome to the new faces. And that's the new faces. I was wondering what you were doing over there. This is a great answer to that question. Okay, so thank you
They
all.
can't stay away.
Now legislative report.
Commissioners, you have in your packet the updated legislative report that added the foster families and foster parents recommendation to the definition of relative within the gift law. So I've already had conversation with Senate staff about that and look forward to meeting with them. In the Senate, President Ben Albritton announced his committee chairs for the upcoming session. He named Senator Don Gates as the chair of the Ethics and Elections Committee, and you'll note that he's a former member of this commission as well and has championed a number of ethics packages in the past. And so we look forward to working with him on your recommendations to see if he might be amenable to having some of those bills heard in his committee. Also in the House, Speaker announced his committee structure for the next 2 years. He appointed Representative Sam Garrison as chair of the Rules and Ethics Committee. Along with that, there's a number of new staff members in place in the House, so we look forward to getting to know them and working with them. You know, as I've mentioned in the past, a key part of the commission's success with the legislature are our members. So for those of you who have relationships with folks in the House and Senate, you know, who are willing to reach out and ask them to help us out, please let me know, make introductions. Steve and I will be working on your behalf, but know that we may be calling you and asking you to help us out in that regard. That concludes my legislative report, unless there are any questions or comments. The last is e-filing, and you'll be glad to know I really don't have much to say about e-filing at this point. Fines and appeals roll out as a part of electronic filing in 2025. I believe those are going to roll out in early 2025, and we're looking forward to that. We're currently working on finding those who have not yet filed for this year and our plans for those appeals, and also working on our call center plans for financial disclosure season, and you'll be getting more information on that in future meetings, and that concludes all of my reports.
All right, and with that, is there a motion to adjourn the public session? Really?
Moved.
Is there a second? All in favor?
Aye.
Aye.